Good morning, everybody, and welcome. I'm just going to leave this for another couple of minutes. There's still a lot of people joining, so I'm just going to leave this for one moment for us to leave it till 11:03, and then I'll start, all right? All right, good morning, everyone. Thank you very much for joining me today, and welcome to our webinar on looking at the new positive duty and the Respect at Work guidelines. I hope this session is going to be useful for you. Before I get started, I'd like to thank everybody for joining me and in this web-based meeting, and firstly acknowledge the traditional owners of the land on which I'm currently based, the Wurundjeri people of the Kulin Nation. And I would like to take a moment to pay my respects to their elders, past, present, and future, and acknowledge the rich culture and history that they brought to our beautiful country. So I'd like to first off by starting to look at what we're going to cover today. And this is a really big and broad topic. I'm not going to be able to get through everything. I do welcome you to put questions and answers through the chat. If it's along the lines of what I'm talking to, I'll try and incorporate it in what I'm saying. If not, at the conclusion of today's session, what I will do is go through all of your questions and create a set of answers that we will then distribute in written form. So any questions that we've got, we'll do our very best to answer them. If not in the seminar, then later. So today's session, we're going to go through the Respect at Work laws, have a look at what they are. We're going to have a look at what is and isn't sexual harassment, the consequences of it. We're going to look a lot in relation to the positive duties for leaders and looking at a framework for good practice. We're going to look at sexual harassment prevention. We'll have a very quick look at how SafeTrack can help you. And we've got a couple of questions and answers at the end, the commonly asked questions that I'm going to address. So first of all, before we start, I would like to start with a poll. And I'm just going to bring up this poll functionality, and hopefully I will launch this and ask you how familiar you are with the new workplace laws. I'll just give you a moment to respond to that. And it's looking like we are mostly somewhat familiar, which is good that we've got some idea. Hopefully by the end of today's session, you'll be feeling a little more familiar, and you'll see that for very few people are feeling very familiar, and it is a whole new set of legislation, so I understand that. But keep in mind, we've only got a short amount of time in which to be compliant with that legislation. So at the moment, time is of the essence. So I'm going to go ahead and end that poll. You can see the results. We've got 122 people that are somewhat familiar. Okay, I'm going to go ahead and stop sharing that. And we're going to move through onto the next slide. So in November of 22, the Federal Parliament passed the Anti-Discrimination and Human Rights Legislation Amendment, the Respect at Work Bill, which introduced several amendments to the Sex Discrimination Act, and it also created changes to the model workplace health and safety laws and to the Fair Work. Now, essentially together, those laws are a major change as they move organisations to moving from having a prevention focus in relation to sexual harassment. The amendments impose a positive duty on employers to take reasonable and proportionate measures to prevent and eliminate sexual harassment in their workplaces. These amendments represent a very significant shift from a response or reactive-based approach to one which is more proactive and focused on prevention. In addition, powers of enforcement have been given to the Australian Human Rights Commission to enforce the positive duty obligation. Effectively, the AHRC will now act as a regulator in relation to the Respect at Work laws. They can now do things such as prepare and publish guidelines for compliance, which they have done a marvellous job of, and the Respect at Work website is probably one of the best websites from a regulator in terms of really clearly setting out your obligations and your duties and giving you a lot of resources in which to help your organisation comply. So if you are not familiar with the workplace health and safety laws, I strongly encourage you to have a look at their website and to take a lot of the guidance from there. In terms of other things that they can do, they can now inquire into matters of systematic or suspected systemic unlawful discrimination and non-compliance with the duty. They have the power to inquire into any matter that may relate to that systematic unlawful discrimination or suspected systemic unlawful sexual harassment, including conduct within individual businesses or across an industry or sector. So, for instance, if they see that there's systematic harassment across a specific sector, they will likely investigate that entire sector. Now, there have been some results done in relation to what sectors are most at risk, and I would encourage you to look at those on the website, as if you are within one of those industries, it is likely the AHRC will be looking to your industry in relation to the practices your individual organisations may be taking to prevent sexual harassment. Now, they have the ability to deal with complaints received up to 24 months after an alleged act, and that these powers will actually come into effect on the 12th of December of this year. So when they were given their powers, they were given 12 months. That 12 months begins on the 12th of December. So if you haven't yet done anything towards meeting your positive duties, you need to do so now. Time is of the essence, and you must be seen to be doing things to prevent sexual harassment in your workplace or in environment. First of all, let's have a look at what sexual harassment is and is not. So under the Respect at Work laws, sexual harassment is defined as any behaviour that is sexual in nature that a reasonable person would anticipate would make another person feel offended, humiliated, or intimidated. Sexual harassment can take many forms. This can include your traditional if you like, unwelcome physical contact, such as touching, hugging, kissing, or any other type of physical contact that is not wanted or requested. Now, I would call this the more familiar stage of sexual harassment, of which everyone's familiar. However, the more nuanced forms of sexual harassment can include verbal abuse and harassment. That can include anything such as sexual jokes, innuendos, insults, slurs that are of a sexual nature. It can include requests for sexual favours. So this might include requests for sexual favours in exchange for work-related benefits or threats, or to withdraw workplace benefits if sexual favours are not granted. It can include the display of offensive material. So that could include sharing sexually explicit pictures, images, sharing videos, or other materials in the workplace that are of a sexual nature. And it can also include stalking and cyberstalking. So that can include any type of unwanted contact or attention to somebody online that is of a sexual nature. Sexual harassment can be committed by anybody in the workplace. That can include supervisors, colleagues, customers, or clients, and can occur in any form of social communication, including face-to-face, online, or on social media. So what is incorporated in sexual harassment is very, very broad, and it is important to note that the behaviour does not have to be directed towards the person experiencing the harassment for it to be considered sexual harassment. I've just had a comment through the chat asking if this has been recorded. Yes, it is being recorded, and we can distribute it after the session finishes if you would like. Moving on to what is not considered sexual harassment. I would say that in the workplace, it is very advisable to take a really conservative view as to your behaviour and to avoid allegations of inappropriate behaviour, such as sexual harassment. But there are certain behaviours that are going to always be considered reasonable and not sexual harassment. So reasonable management of work-related comment or conduct in connection with performance of the employee's duties, such as performance management, disciplinary action, not given in a sexual way, will not be considered sexual harassment. There will be social gatherings and invitations that are consensual and not linked to an advancement of a job offer or special job perks. That would probably be okay. But again, best to check the policy in relation to that. Some organisations are creating policies that will prohibit any sort of physical contact from people within the workplace. Occasional compliments, not of a sexual nature, which are provided in a professional and respectful manner. If you're not sure what that incorporates, I would probably avoid compliments if you're not sure what is and is not of a sexual nature, or perhaps address HR in relation to some training on that particular topic. And mutual attractions and friendships, which may lead to consensual and acceptable behaviours. And again, it's useful to look at your policies in relation to that. And it's important to ensure that there is not a power imbalance in a consensual relationship within the workplace. So the consequences of sexual harassment are that a person who sexually harasses somebody can actually be held primarily responsible for their behaviour and may, even in a workplace, be found to face personal consequences. And that might include losing a job, harming their reputation. It can include significantly damaging their career, and it can even expose them to personal liability. So just because you're doing something in the workplace doesn't mean that it's just your workplace that will be held liable. You may well be held personally liable under the legislation. However, an organisation is also potentially going to be held liable for the actions of their workers if they sexually harass somebody, that it may be an agent, a contractor, anybody within the workplace, unless they can show that they have taken all reasonable steps to prevent the sexual harassment from occurring. This is known as vicarious liability. The consequences for breaching the legislation are widespread, and in addition to significant fines and penalties, include things such as reputation and brand damage, staff retention and attraction, and increasingly an impact on short and long-term shareholder values. I'm going to run a second poll now. We're going to look at sorry, I'm just going to launch the poll. Sorry, I'll launch the next poll and go ahead and ask you how confident you are that your company is currently in compliance with the new Respect at Work laws. Very confident, somewhat confident, or not confident at all. And keep in mind, these answers are completely confidential. I can't say who's suing what, so you can answer them confidentially. And we can see again, a bit of a mix. Some organisations very confident, which is wonderful, though some that are somewhat confident and some that are not confident at all. I'm going to go ahead and end that poll and share those results. Go ahead and stop sharing. Oh, sorry. I'm going to go ahead and look at the new key amendment to the Respect at Work legislation, which was the introduction of a positive duty on leaders to take reasonable and proportionate measures to eliminate workplace sexual harassment. The scope of the positive duty is very broad, and sorry, I'm just having trouble sharing. There you go. Sorry, I hope that's all okay with you. This is very broad, and it ensures that coverage extends to employees, workers, agents, third parties with whom the employees come into contact with. It even considers how third parties treat employees in the work contact. For example, how customers, delivery drivers, and third-party vendors treat your staff will come within the bounds of the positive duty. So beginning in December 12 this year, the Commission will have the authority to initiate inquiries if they suspect an entity isn't adhering to the positive duty. And these suspicions can arise from a variety of sources, including government agencies, reports by affected individuals, worker unions, or media reports. They can then go ahead and offer recommendations after investigating an organisation's adherence to the positive duty. So they can come in and audit your organisation for your adherence. They can issue official notices dictating what actions an organisation should take to achieve compliance. They can approach the federal courts to ensure organisations follow the compliance notice. They can engage in legally binding agreements with organisations, specifying the actions they must take or avoid taking, and of course recommend punishments and penalties in relation to any potential infringements. They will look specifically to the actions of leaders and the roles that they have played in promoting a positive workplace culture. They're going to look at the role of leaders and what they've done to initiate change and improvement in the workplace. And they would want to be seeing that leaders are involved and accountable for culture, ensuring sexual harassment is prevented in the workforce. And a couple of slides, we're going to look into the type of steps leaders should be taking and a type of framework for following to ensure adherence to these things. Now, while the Act is explicit in its requirements, it's also adaptable to organisations of variable sizes and structures. So the AHRC has been very clear in understanding that businesses differ in size and nature, and when becoming compliant, it's financially viable. What's financially viable for a large organisation may be impractical and costly for a small organisation. So there's definite a proportional application of the duty that's going to be held according to the size of organisation that you are. So what constitutes all reasonable steps is not actually defined in the Sex Discrimination Act, and it's determined on a case-to-case basis. And what's reasonable for a large corporation is not necessarily going to be reasonable for a small corporation. So when deciding what level of preventative action is reasonable, employers should consider the nature of their own individual workplace. So that's going to, and the sort of things that they're going to look at is training. So the size and structure of the organisation. Large organisations may need to organise formal information and training sessions to ensure that all employees are aware and understand the organisation's sexual harassment policy. In small businesses, it might be held to be reasonable to provide copies of a policy to employees and have an informal discussion with employees to ensure they understand the policy. So in terms of available resources, in a large organisation, it might be reasonable that a large significant budget be allocated to sexual harassment training and that all employees attend the training. In small business, where finances are limited, it may not be reasonable to send in each employee to a sexual harassment training session, but instead it might be that they do an online course, might be fill out a questionnaire. They might be designed to do a survey that ensures employees understand the policy. So if there is a history of sexual harassment in the workplace and of gender hostility, employers may have to take particularly strong steps to combat harassment in circumstances. So if you've got an organisation that has no claims, does not have a history of any of this sort of thing, then the steps that you may take may not be as great as some that have had a history of it. So any relevant factor, including geographic isolation of the work location, duties which require employees to work in close physical proximity or where there are live-in arrangements, all of these things are going to go into determining what would be reasonable for your workplace and the persons that work for you. In terms of the steps that are going to be required to meet the positive duty, where the AHRC has recommended this looks like a fairly regular type of what we would look at an ongoing cycle of continuous improvement in compliance. And it's going to look to leadership, culture, knowledge, risk management, support, reporting and response, monitoring, evaluation, and transparency. Now, if we were to break that down into a fair work, into something that looked like a positive framework, I've created this section, which has been, I guess, inspired by a lot of the resources that have been created by the AHRC, and they have a wonderful PDF that is very voluminous in terms of these sections and all the types of actions that your organisation can be taking within each of these sections. So I've done a very brief summary of it to give you a type of look at what your organisation should be looking at doing in order to comply with your positive duty. So first of all, we're going to look at leadership and governance. So that's going to probably require training for your leaders, training for all employees indeed. But in relation to our leaders, we're going to look to things like accountability for KPIs in relation to things like gender equality, looking at training in relation to unconscious bias. We're going to look at our recruitment practices and ensure that we've eliminated discrimination and bias from those employment practices, and that we are going about ensuring that we are taking advances in our leadership from a governance and leadership level for advancing safe, respectful, and inclusive cultures. In terms of knowledge, we're going to look for things like training, potentially customized training to your organisation and to your job roles to address either the idea of sexual harassment elimination in the workplace as a whole, or to address specific issues that you know that your workplace has suffered in the past, but you need to overall ensure that all staff understand safe and respectful and inclusive conduct. And that will include things like refresher training to maintain up-to-date knowledge and ensure that you've got training records and policies that are updated and in line with the law. In terms of our culture, we need to be ensuring our workplaces ensure diversity and that appropriate relationships are modelled by senior leaders. The company needs to be continually investing in cultural initiatives and models good culture to instill appropriate actions and behaviours. We need to ensure that our policies reflect the type of culture that we're seeking to endorse, and that those policies and procedures are kept up to date with the law and the changes in the legislation. In terms of risk assessment and transparency, we want to look to organisations to do things like surveying and benchmarking. And that's not just simply in relation to have you seen, witnessed, or experienced sexual harassment. It's going to be in relation to things like the culture, the leadership, diversity and inclusion, opportunity, harassment, and ideally reporting on detailed benchmarking. The beauty of running a benchmark survey is that it allows you to capture your organisation's position at a point in time. Then you can go through and create new initiatives, new training measures, new cultural initiatives. And then over time, if we then benchmark again, hopefully those initiatives, you'll be able to see movement in your benchmarking in a positive and improving manner. And then in the event that something were to happen in which your organisation or somebody in your organisation breached the law, if you are able to show the Commission that you've made significant strides and continue to make strides towards preventing sexual harassment, then the likelihood of you being found not in contravention to the legislation is going to be minimised. We want to make sure that your organisation has the right support mechanisms in there, that they are accessible and effective for any victims of sexual harassment, and that responding staff are well trained in trauma-informed reporting, and that the individual reporting conduct is well supported by the organisation. And that will mean that you're going to need to have a clear framework, a clear reporting framework, and open communications about acceptable, non-acceptable behaviours, and an environment where employees feel safe to report breaches to the legislation and feel free of recrimination for making such a report. Need to ensure that the organisation has a process and a culture of fair, unbiased and lawful investigations, and that the organisation is continually measuring and reviewing the effectiveness of its initiatives with a view to permanent and continual improvement. And I would say that the same with all compliance initiatives. You don't arrive and say, I am compliant. It's a permanent journey, and it's a permanent cycle of improving what you do, measuring what you do, and adjusting what you do to combat new laws, new changes in behaviour, new staff, new policies, new procedures, and ensure all of those are working together on an ongoing basis. On to the next slide. I would like to know what steps your company has taken to ensure compliance with the new Respect at Work laws. So I'm going to go ahead and start this poll. Hang on. Go ahead and launch this. And if you can simply put in place which of those things that we've been talking about, leadership training, surveying, training and education, reviewing and updating policies, creating new processes, any other things that your organisations have been doing, we'll have a look at what that looks like and where we probably need to put a little bit more action and effort into. So we can see that many organisations have trained and educated employees. That's terrific. Less have educated leaders, which is interesting because the training probably needs to start with leadership. It's great to educate our staff, but if our leaders aren't following that training, then the effectiveness of the training is going to be limited. Surveying staff is much less. I'd like to remind you all that surveying staff is a wonderful means of benchmarking where your organisation's actually at the moment, if there are any issues going on that you don't know about, and where there might be issues that you need to be addressing. It looks like a lot of people, 73% of people have, I'll go ahead and end that poll and share the results so you can see that. We've reviewed and updated policies. That's terrific. And that's many have actually started to create new reporting processes. So that's great too. And that might be just ensuring staff know where to report to and having a number of persons in your organisation trained and ready to accept those reports. Or it might be ensuring that you've got a complete whistleblowing solution in place and all staff are aware of where they could report impartially and confidentially through a third-party service. And just we've had a couple of questions. We've had a couple of questions about the frequency of training. I'm actually going to address that as we go through into a couple of Q&As because it's a really good one and it's a common one we're asked. And trauma-informed training, we've been asked, do we offer it? We actually don't offer trauma-informed training as an online course. It's something that I would recommend that you look to do externally and a face-to-face environment. I think what we can do is we can recommend a place that you can go, but there are places to do so. And certainly the people who are designated as reporting people in your organizations should be trained in such. I'm just going to remove that poll. In relation to, just quickly, how SafeTrack can help in relation to some of these things, it's not actually sufficient that you simply train your staff in sexual harassment. Sexual harassment is but one thing. You need to be looking at training your leaders in the positive duty and what it is and what they need to be doing. We need to be training staff in psychosocial hazards. We need to be looking at discrimination, bullying and harassment, diversity and inclusion, especially at a leadership level, workplace health and safety, unconscious bias, really investing in management and leadership training, and looking at refreshing our code of conduct and ensure all of those elements are included in your code of conduct and that your staff is well trained in your code of conduct. Now, SafeTrack's got online learning courses in relation to all of those topics. We also offer booster learns on various topics. So at the moment, if you subscribe to Workplace Health and Safety, you would have received a booster learn on psychosocial hazards. Of course, that's a free supplement to your Workplace Health and Safety subscription. And in the next year, we will have updated Workplace Health and Safety to include a whole section on psychosocial hazards. We also offer a customization and a bespoke design service. That means we take any of those courses and we can customize them to your own requirements. So increasingly, we're seeing companies not wanting to just roll out an off-the-shelf training course. They're actually wanting the course to look and feel like their own organization's course and to reflect specific things about their organization. Some people are even going a lot further, incorporating videos of their staff, videos of leadership, incorporating policies that and practices and procedures in relation to what their organisation's doing. But we make sure the course is kept up to speed with the legislation. And when there's ever legislative change, we will make those updates for you. So you don't have to worry about keeping those courses updated and monitoring the legislation. We do that for you. We offer all of those courses to you either as SCORM or on our platform. So if you have a learning management system, we can deliver those courses to you into your learning management system as a SCORM file. If you don't have a learning management system, we have an online platform that we can offer you, and we can roll those courses out to your staff. We offer a white glove compliance rollout service. So if you don't have anyone who wants to run the platform, we'll do it for you and we'll roll it out to all of your staff. We also enable the distribution of policies so that you can distribute your policies and have sign off to your policies through the platform. So this actually starts to create for your record keeping of your efforts to comply with the positive duty. So we can show that you enrolled your staff, you ensure they completed training, we will test your staff on their knowledge. We can give you reports on where there's an inadequate knowledge or a weakness of knowledge that may promote conduct risk in that particular area. We can on our platform also survey staff, and we've created surveying for a default survey for sexual harassment and culture in your workplace that you can roll out, and we'll run that survey for you anonymously so that it doesn't get reported to you. We simply report the results, so it's all anonymous for your staff. And we can also offer you an audit that allows you to check off what your organisation has and has not done and how that fits with what you're required to do under the legislation. So all of those things are available on our platform. So I'm going to move on to a couple of questions. And these are some that we've received by some clients, and they're just repeated and all the same question all the time. So I think these are the most commonly ones I'm going to try and address. So what should be contained in a workplace policy to prevent sexual harassment? So first of all, it's absolutely vital that you have a policy on this topic. So if you don't, you need one. We do have a default policy that we can offer you with subscribed clients. But again, it's a starting point. It should be about what your organisation is going to do and how you're going to address sexual harassment in the workplace. It needs to be a clear statement that sexual harassment will not be tolerated in your workplace. And that includes from third parties, clients, and customers. And to that end, you need to be thinking about how you're going to communicate that policy to your third parties and to your customers so that you could look to ensure that they understand the policies that your organisation has. We need to set workplace standards about behaviours, attitudes, and languages that disrespects or excludes people based on gender, gender identity, sexual orientation, or assumptions about dominant gender stereotypes and socially prescribed gender roles. And that is why something like diversity training and discrimination training are essential in terms of you complying with this duty. We need to define what sexual harassment is and recognise that it is unlawful. You probably want to incorporate some examples of behaviours that are and are not allowed. You want to address including the appropriate use of social media and technology, and again, what is and isn't allowed. And you want to control the measures to prevent sexual harassment relevant to your workplace. So the duties of all levels of worker, including managers and supervisors, and your duties as an employer. So what would be the consequences of breaching the policy, what a worker could do if they experience sexual harassment, where do they report it, what a worker should do if they witness sexual harassment, even if they did not experience it. The process that the organisation will undertake once a report is received, how they're going to deal with concerns, how you're going to keep people safe in your workplace, and is there a manner that the issue can be dealt with by an external or independent third party that may be used to investigate, and any support services available for any people that may have experienced sexual harassment. So your policy should address all of those things. The next question that I have is, how can we evaluate the effectiveness of our efforts to prevent and address sexual harassment and make changes if necessary? So in order to evaluate the effectiveness of our efforts to prevent sexual harassment, it's important to have a comprehensive approach that includes regular feedback, data, and analysis. Some steps, as I've mentioned before, can include regular employee survey and benchmarking, conducting anonymous surveys of employees to gather their perceptions and experiences regarding sexual harassment in the workplace, incident reporting and analysis, so looking at the number and types of incidents reported, as well as the response times and the effectiveness of investigations. And really, we want to be looking at those reports. We want to be looking at any patterning of reports. If it's the same sort of thing being reported, whether it's jokes, innuendos, slurs, graphic imagery, online, if it's coming from a specific person, your organisation needs to be able to get that information in order that it can further train or address and eliminate that harassment from occurring. In terms of training, we need to be able to measure the effectiveness of training. So just training your staff isn't sufficient. We want to be able to measure the impact of that training. So usually we would look to do feedback on the training and maybe benchmarking knowledge before and after the training. Testing of understanding after a training course is essential. It's not enough to just train people. You want to test their knowledge afterwards to ensure that they have the requisite or adequate level of knowledge after the training course. We want to make sure that they really do understand what is sexual harassment, what's not sexual harassment, and how to report it, what to do if they experience it. We want to ensure that our leaders are trained in what to do if any of their staff experience it or report it. Culture assessments are growing in importance, and regularly assessing the overall culture of the organisation to assess where improvements can be made. Management accountability, we want to be able to hold managers and leaders accountable for preventing and addressing sexual harassment in the workplace and regularly addressing performance in this area. So gone are the days when leaders' KPIs are simply about financial success or improvement. They need to be held accountable for diversity factors, things like diversity in the workplace, wage equality. Wherever there is a power imbalance, you have a higher likelihood of sexual harassment occurring. So removal of power imbalances, that's typically gender imbalances. We want to make sure that we want to be making improvements in those areas, and that our leaders' performance is rated on improving these type of areas. And we've now got really good benchmarking for those sort of things, such as wage gaps, gender diversity, not just across the organisation, but in management levels. Racial diversity, also equally important. So all our sort of ESG type measures can be used to hold our leaders accountable for improving culture on an ongoing basis. How are our courses delivered? I mentioned earlier they're available both online via your SCORM file or via our platform. So we've got a lot of different licensing options in relation to how you subscribe. We have a whole lot of different formats in relation to the type of format that might suit you and your staff. So they, as I mentioned, they can be customized, and we need to make sure that they are all courses that you're training your staff on, as I mentioned earlier, are tested at the end. So all SafeTrack courses incorporate a test to ensure that your learners have an adequacy of knowledge at the end of the test. On a SafeTrack platform, we will typically set a pass mark of 80 to 90%. Increasingly, we're seeing organisations set a pass mark of 100%, ensuring that staff understand everything about the content of a course. If you look at a pass mark of 80%, it effectively means staff don't understand 20% of it. That 20% of it could well be the area in which they go about and breach that area of law. So keep that in mind when you're looking at setting pass marks. Keep in mind you can also customize test questions. So you can make them test questions that you think are particularly relevant to your own organisation. So going back to the legislation again, we've got to recall that we've got to take reasonable and proportional measures to discharge the duties, and that's going to vary and depend on the size and nature of the company's resources, financial or otherwise, and the practicability and costs to those steps. So there's no one size fits all in what is the right training for your organisation to do, but definitely consider the mode of training and the different modes of training that are available. So face-to-face training is a fabulous way of training staff, and we believe that a blended learning approach is probably the ideal method. But any face-to-face learn, and what I mean by blended is some face-to-face, some written, some online, so that you're getting learning from all different standards, because different people learn in different ways, and you never know which learning method is going to resonate with each of your staff. So having a blended methodology is typically regarded as the gold standard. However, face-to-face training has its issues in terms of getting your trainer out to lots of different locations is difficult. Getting people together at the same time is difficult. So in those circumstances, certainly online learning makes a lot of sense. We can roll it out, people can complete the training, but we need to ensure that the training is engaging, it is relevant, it is up to date with the law, and that it does test users at the end of it. So in certainly terms of cost, online training reduces costs significantly. So for an organisation without huge budgets that can afford face-to-face training for all personnel, online training is an excellent measure. In terms of what the AHRC has declared as acceptable training, we would say that the guidelines that the AHRC released in relation to education and training stated that, and I'll quote from it, examples of training to prevent and respond to unlawful behaviours in the workplace may include formal face-to-face or virtual workshops, on-the-job training, e-learning courses that relate to the individual or a group's relevant roles and responsibilities. So virtual, face-to-face or online are all recognised standards and acceptable forms of training according to the AHRC. But it's important to ensure that that learning is ongoing and repeated. Training is not a one-off event. So what does ongoing and repeated look like? It needs to be at least annual. If not, even if it's annual training, it needs to be reinforced by continual distribution and acceptance of policies, discussion in the workplace of things that are going on, advancements, changes to policies, procedures, improvements, ensuring that staff understand reporting, what's going on, that there's transparency in the organisation of any issues for improvement and how they're doing it, so that it's not simply a one-off action, but it's supported by ongoing and repeated actions of the organisations. We've now been operable for 24 years. And in our 24 years of operation, not one SafeTrack client has been found to have an inadequate training program in place. So I'd say that's a pretty good record. In terms of what's in our content, we ensure that our content is quite thorough in terms of what we address in the training course. And we recommend and usually insist on clients rolling it out annually, as that is definitely the gold standard. And an organisation is going to struggle to be shown by a regulator to have put inadequate training in place if they've been rolling out regular and ongoing training. Many of our clients have been with us for 10, 15 years, and they will have training records for 15 years showing a record of doing this for a really long period of time. That's the sort of thing that you want to be able to show a regulator. You also potentially want to be able to show a regulator that you've distributed your policies, that staff have accepted and agreed to comply with your policies, that you've surveyed and you've benchmarked, and you've got a long history of doing it. If that's all on one platform, that's a great way to do it. So I've just got a couple of other questions that I will address. The risk sectors have been listed. There was mining, finance, IT, and technology, I think, were the three main areas. And a lot of those areas are areas where there is a lack of diversity in the workplaces. So typically we're looking at sexual gender diversity and lack of gender diversity. And increasingly we're seeing the industries with a lack of gender diversity having an increased incidence of sexual harassment. Again, we go down to the concept of inadequate power imbalances. And where there's power imbalances, there's often a higher prevalence of sexual harassment. So the AHRC will be looking for industries with high levels of gender imbalance. And if there is repeated or ongoing reports from within those industries, they will likely investigate that entire sector. So that's sort of the guidelines that's come through from them. We've had a question in relation to a company with a headcount of less than 20. What sort of measures does a company need to take to be sufficient? Again, the AHRC does not say for a company of 20, this is what you need to do. It needs to be reasonable and proportional. So you need to have a policy as a minimum. You need to have educated your staff in that policy. So that policy needs to address all the things that I said it did. Need to ensure that all staff understand there's a no tolerance approach. That needs to be endorsed and followed by the leadership of that organisation. And I would say that the actions of leaders in a small business are so crucial to creating that culture. They're crucial anywhere, but in a small business, you're really setting the standard because they're not looking to anybody else. They're not looking to managers. They're just looking to leaders, directors, etc. You would also want to have given some training, whether that's online or whether it's face-to-face. That's probably up to the organisation and what suits the organisation best. But it's not expensive to train 20 staff in your policy and in the laws in relation to ensuring they understand them and know what they need to do to comply and know what's okay for your workplace. Is it sufficient to have an EO policy with sexual harassment included or have a separate policy? Yes, see, it's an interesting question because it also falls in relation to the workplace health and safety laws. So, sexual harassment will also fall within the workplace health and safety laws for psychosocial hazard, potentially. So it actually fits into several laws. I think that as long as you've got policy firmly addressing sexual harassment as a topic, I think it's probably sufficient, but I would err on the path of caution, and I would have a separate policy for sexual harassment to very clearly call out from your organisation the law, what the law states, how your organisation's following it, and how it's treated as potentially different from EEO. There are things like trauma-informed reporting that potentially you need, and potentially more confidential reporting that may be a little different in relation to sexual harassment that may be for your standard EEO or workplace health and safety issues. They've been asked whether or not we need to look at psychosocial hazard training separate, and the answer is yes, you absolutely need to be training the staff on this. So it doesn't just incorporate sexual harassment. It's things like overworking, stress in the workplace, mental health. It's much broader than simply sexual harassment. Incorporates sexual harassment, but much broader. An essential new update to the workplace health and safety laws, and essential that you're actually addressing that. So I think that is all that I probably have time for today. Before I finish, though, I just wanted to point you to the direction in relation to information and resources that are available to you. I recommend that you utilise these assets for looking through your obligations and following them. So the information for organisations, again, I fully commend to you the Respect at Work website. The Good Practice Framework, I gave you an excerpt of it, but the Good Practice Framework that's in its entirety on the Respect at Work website, is sensational. The Respect at Work website references the Champions to Change website, which is really about preventing sexual harassment in the workplace from a leadership perspective. So for your leaders, that's a really great resource. Safe Work Australia, they have an excellent resources available to you for preventing sexual harassment. And Our Watch is an organisation recommended by Respect at Work for offering advice and information to support employees and to understand and address the drivers of violence against women. So it's a very good additional resource for you to look at. It is really important that the information for individuals on the right-hand side of this page is made available to your staff. So I would recommend that in any policy or in any training course that you're going to give your staff, that you ensure that you utilise these references for your staff to know that they have access to in the event that they do experience sexual harassment, and that they have support available to them. I've had a question just now about how the new laws will be distributed to businesses. Most businesses I know I have spoken to are not aware of this legislation. In Australia, you are, as a person and an organisation, responsible for yourself ensuring that you know what the laws are as they change. So lack of knowledge is not a defence to non-compliance with legislation. So however your organisation goes about learning about these laws is up to an individual organisation. Some organisations will have an HR team that will monitor this type of legislation. Some will have a legal team. Some will have external lawyers. Some SafeTrack subscribers, of course, have access to our course portal, which shows them any impending changes to legislation and changes that would impact their learning or their courseware. But importantly, all of the regulators, so if you look to ASIC, APRA, AHRC, WorkSafe, Fair Work, they have wonderful resources available. They are really very, very educational websites these days, and really do provide the basic nexus of what you need to be doing. Australia is one of the most tightly regulated countries in the world, and the vast array of legislation that we need to be following is enormous. And it's actually where organisations like SafeTrack are really coming into their own, because we monitor the legislation for you. And for the legislation that affects your organisation, your legal counsel or your HR people are busy doing enough other things than to be monitoring all the legislation as well. So relying on us to ensure that your training is up to date and in line with legislative change is really a sigh of relief for many organisations that subscribe to our services, because we can do the worrying for them. And we subscribe to all the legislative update services, so we're aware of what's going on. You mentioned client organisations could access your default policy. When you subscribe to our courseware, you can access the default policy. It's a question there. And would you recommendations be when most of our disability support workers directly support clients in their independent homes? Many of these clients have acquired brain injuries, who have been known to sexually harass employees at times. Yep, you've got a really difficult work environment. We've actually worked with an in-home care worker, a care work facility in the past. We created very custom training courses. A lot of their workers were actually, they had English as a second language, and they had not high levels of education. So we created animated training scenarios for them So, and we actually replicated some of the situations that went on in the homes. There's situations where, for instance, they had to shower elderly people and they were sexually harassed in these environments. So our training courses trained them in what the circumstances that could arrange, what they had to do in the environment that happened, what resources were available, how they could report it and how they would be supported afterwards, and what they had to do with the person in that particular situation. So again, training courses that relate to your exact policies. If you've got a workplace where you know this happens, this legislation really applies to you, and you need to be really vigilant in relation to what you're doing and how you're training your staff and the policies and the procedures that you're implementing. I would say you also need to be educating your clients that if you're going to come into the home, these things aren't available. If you're dealing with disabled workers, aged persons, involving their family in that education process is another thing that needs to be done. So policies, procedures about what happens if these sort of events occur, that the safety and protection of your staff is paramount at all times. They're the type of things that you need to be looking at. I've got time for one more question, but I can't read it for some reason. I can't scroll down. Sorry, that's there you go. Do you use law firms to update your training? Yeah, we actually have lawyers that author our training internally, but then we outsource our training as a final check mark to a third-party law firm who checks it off and ensures that we haven't missed anything and that it is compliant with the laws. So we have a legal sign-off on all of our courses from an external firm or firms. That is, thanks everyone for your great questions. It is a diverse and interesting area of the law and complex in terms of compliance. It is a massive change to go from sexual harassment not allowed to you must prevent sexual harassment. It is an enormous change. It is the biggest change in legislation that I've seen in my 30 years in law. And in terms of the change that it means that your organisation needs to be making, I've never seen anything so onerous. So it really means a fundamental shift in workplace behaviours, right down to your gender imbalances. So it's, you know, if you have a gender imbalance and you've got sexual harassment going on, you are likely going to get pinged by the AHRC in the event of sexual harassment, and you haven't done sufficient things to address that gender imbalance. That's the type of thing we're looking at. So this is, you know, in terms of changing the world and changing sexual harassment, this is the biggest thing that could have happened. It's enormous legislation. It's fundamental change. And the sooner that all of you and your organizations get on to making changes in your organization, the better. And remember, the clock is absolutely ticking. 12th of December is when the AHRC becomes a regulator, where your organization must have things in place. To the extent that you don't have leadership training or training in any of the courses that I mentioned today, quick call to SafeTrack. We will set you up with courses. We can roll you out very quickly, and we can get you online very, very quickly and a solution in place before the 12th of December, hopefully. That's all I've got today. Thank you very much for your attendance. Really appreciate it. I hope this has been very useful for you, and wish you well in complying with your new obligations. Thanks very much, everybody.